Justice Kagan?
So at the risk of a little bit repeating some of the discussion, it seems to me that there are four principal, there may be others, but there are four principal kinds of taxation that Congress has repeatedly countenanced and that this Court certainly has done nothing to get in the way of, that you have to distinguish here. And I just want to make sure I understand your distinctions and whether there's a single distinction that sort of covers all of these or whether each one has a different explanation. So here are my four. It's Subpart F, it's S corporations, it's partnerships, and it's taxing on an accrual basis. So give me why it is that you think we can decide for you without putting any of those kinds of very established taxation schemes at risk.
At a 10,000-foot level, Your Honor, they all hew to the realization line as it's been developed in the Court's cases and by historical precedent.
See, I would have thought that none of them hew to the realization line.
I think that...
I mean, that's why this is my question, I guess.
Again, Subpart F uses that familiar mechanism of simply attributing income to the person who earned it, even if they've directed it somewhere else, and taxes of that nature have long been justified on that basis. S corporations, again, are by election of the shareholders. If they concede that this is in fact their income and that's how they're operating their business, I don't think that the government would have any basis not to take them at their word, should the government choose to do so. So far as partnerships are concerned, again, there's no separate person that sits above the shareholders the partners of a partnership, and those have always been treated differently going back to the Dartmouth College case, and where it wasn't even new at that point. But with respect to income, going back to Gibbons versus Mahan, which recognized it as a well-established principle at that point that corporations are different in that respect from partnerships. Indeed, that was the basis on which McComber rejected the same argument. And then finally, with respect to accrual, the Court already addressed that issue in the safety car heating and lighting case, where it held that standard 16th Amendment realization principles, and it cited among others McComber, applied to the accrual method of accounting. So, whatever question there might be about that methodology and its constitutional status, I think at this point that's been long established and is water under the bridge.
Mm-hmm. And can I go back to Justice Thomas's question, which is your own definition of realization? And I'm just going to give you McComber's and tell me if you agree with it or disagree with it or think it needs to be modified. McComber said, that which proceeds from the property is severed from the capital, is received or drawn by the recipient, that is the taxpayer, for his separate use. Is that your definition too?
I think subsequent case law has recognized that the separation concept doesn't necessarily apply in every circumstance, although it does apply in the circumstance of distinguishing shareholders versus corporations.
So for example, in Brune, we've basically ignored this separation requirement, correct?
The Court said that it was applicable in the corporate context, but not necessarily in other contexts. In that example, for example, an improvement that was made to land that was not severable from the land.
And that definition really wouldn't be very good to explain Subpart F. Is that correct, too?
Well, I think what the Court has recognized in subsequent cases is that it's really the concept of realization as opposed to, say, actual receipt that is important. I mean, look, it's
So what you're saying is basically we've left McComber behind.
No. I think the Court's cases through Glenshaw Glass, up through as recently as, say, Indianapolis Power and Light or Banks, recognize that there is something more that is needed than a mere economic gain.
No, I wasn't suggesting that we've left entirely behind any concept of realization. I mean, that's a different question. But that we've left the McComber definition of realization behind.
I think that McComber's holding in that respect remains good law, and I don't think that it's been left behind. McComber goes on to recognize, for example, regarding corporations, that there may be appropriate circumstances for the law to look behind the corporate form to ascertain the true right and actions of the shareholder with respect to income. And so I think McComber taken as a whole does recognize this principle, and it used the best language that occurred to the judges in the context of the case to express that, look, in most cases it's going to be receipt, but in other cases something else may well qualify.